Hi guys, welcome back to my channel. This is Bat Up with Ola. My name is Mujela Olua. Today I want to talk about Locus Standi or Locus Standi. It's a Latin term that means the right of standing before the court. So locus as in a place or the location, standi as in standing. So the location of standing, that is the place of standing that a person has before the court. Locus Standi. So essentially it means the right of a person to appear before the court and be heard, or the right to litigate a matter, the right to come before the court to present one's case and be heard, and for the case to be adjudicated upon. That's Locus Standi or Locus Standi. Now, as a principle or as a concept, Locus Standi goes to the roots of a matter. That is, a party can bring a preliminary objection as to the issue of Locus Standi if a case is instituted in court. So if a plaintiff brings a case to court and the defendant thinks that the plaintiff does not have the right to bring that case or to be heard by the court on that matter, he can bring a preliminary objection, that's a PO, on Locus Standi, so that the court can decide if the plaintiff or the claimant has Locus Standi before it. And how does the court determine that? The court will determine, even from the statement of claim and from the processes that have been filed, from the story that's been told in the claims and in the originating processes, if the plaintiff or claimant has sufficient interest in that matter. That is, if they are sufficiently linked to the course of action for them to now litigate upon it. That's how Locus Standi is determined. Does this person who has brought this matter, do they have sufficient interest in this matter, legal interest now? Are they sufficiently connected to the subject matter, to the rest, to the subject or object of dispute for them to have brought this matter? You know, there are some specialized cases where the courts or the rules of court or the rules or the law has specified who can bring an action in such instances. But in several other cases, the courts will look at the sum total of the processes that's been filed before it to determine if the person that has brought the matter can successfully sue or bring that matter based on their lawful connection to, the fulcrum of the matter. That is, the subject matter, the rest, which is the thing that's been disputed or litigated upon. So that is Locus Standi. Now, Locus Standi, like I said, a preliminary objection can be brought based on Locus Standi, and it can cause a matter to be struck out. But in Attorney General of the Federation and Attorney General of Lagos, it's a 2017 case, the court decided and held that when deciding Locus Standi, the court is deciding if the person that brought the matter can bring the matter, not that if the case or the matter that has been brought can be decided upon. So it could be that a matter is justiciable, that is, that it can be litigated upon, that parties can sue and be sued because of it. But it could be that the person that has now instituted the action is not the rightful person. For instance, in a case of, in a tort, you cannot sue on behalf of someone except you are the lawful guardian or they are in loco parentis in some instances. Okay, if someone has been slapped, assault now. If A has been slapped by B, C cannot institute an action because of A. A has to come before the court once it's an adult under the law and sue for the assault committed against him or her. So the court has this rule and measurement for Locus Standi to ensure that frivolous actions are not brought to the court, and people who have no relation whatsoever to the subject matter of the dispute do not come before the court, litigating or suing upon the matter. More importantly, to prevent meddlesome interlopers, from usurping causes of action that are not their own or that they have no bearing or connection to. So essentially, the court is trying to decide in an action or in a preliminary objection based on Locus Standi. The court is trying to decide the person that has brought this matter, are they connected to this matter sufficiently or well enough for them to actually sue on this matter or litigate this matter, not if the case is justiciable or not. So that's the differentiation that was made in AG Federation and AG Lagos State. It's a 2017 matter. As well, The court has also held that where the court finds that the person that brought the matter does not have locus standi, does not have the authority or the ability to sue or to litigate the matter, the rightful decision of the court is striking out the matter. That's the decision in Adeleke and CBN. It's a 2017 matter as well, a 2017 decided case. So if the court finds that you who have brought the action, you don't have locus standi, the court will strike out the matter. And then the person that can lawfully sue on the matter can bring an action. For instance, when you are suing for ownership or contesting the ownership of a piece of land, it is the person that is claiming to be the owner that can sue. If you are a tenant, you can't sue for ownership. If you are a neighbor, you can't sue for ownership. It is the person who is claiming to be the owner that can sue. You can also apply this logic to several other cases. So you just try to decide the person that has brought this action, are they sufficiently connected under the law to this action? Do they have sufficient legal interest in the subject matter before the court, so that the court also will not work in vain, because the court must not do anything in vain. In order not to waste the time of the court and the time of the litigants, the court will decide an objection based on locus standi as of first importance before even going into the substance of the case. So that is what locus standi is all about. The issue of locus standi goes to the jurisdiction of a court or the court to adjudicate on a matter. So if a person does not have locus standi and has instituted a matter before the court, it means that the court lacks the jurisdiction to hear that person, because that person is not the rightful person to sue. And another thing to take note of is that you cannot cite foreign cases to prove locus standi. Okay, so it's been held that foreign cases cannot be your point of reliance to prove your locus standi in court. No, rather you should be able to connect yourself to the case, the dispute, the subject matter, by showing that either your rights has been infringed upon, or that a privilege has been taken away from you, or that a lawful expectation of yours is being affected by the action or inaction of the defendant. That's the easiest way to prove locus standi. So those are the things that the court will consider when deciding locus standi. It is the right of a person to come before the court to be heard on a subject matter or to sue on a legal dispute. And if the court decides that they have that right, the court will hear them and then decide the substance of the case. And if not, the court will strike out the matter, and then the rightful person in law can sue for the matter. And like I said, there are some persons that have been delineated by law to sue and to be the rightful persons to institute an action in some certain instances. But aside that, the court will look at the statement of claim and the originating processes before it to determine if the person that has sued has sufficient interest to sue in the matter. So that's all I have for you in this video. I will see you in my very next video. Don't forget to subscribe to this.